We love partnering with the University YMCA for this event. We're really excited for today's speaker, but before I hand it off to Mark to introduce our speaker, I do want to share that DSJE is having our annual Social Justice Awards coming up on Thursday, April 16th from 4 to 7 p.m. at the 4:30 to 7 p.m. at the Illini Union. So if you are interested in coming to that, check out our table in the lobby and we can give you some more information. And with that, let me hand it off to Mark from the YMCA.
Hi everyone, good to see you all today. Thanks for coming out. My name is Mark Alexander. I'm the development director here at the Y. Welcome to Friday Forum Café. This is the 99th year we've been doing this program. I'm particularly excited today for our speaker because we went to high school together. This is now the third time I've been able to bring someone that went to Uni High, where I graduated from, in to speak. Nick and I were in theater together. I won't give our classes up to date, but some years ago we were in theater together at Uni, and recently I was looking at his Instagram and he just puts up, his life updates, and one does, but he was also throwing up some really interesting court cases because he works, as you're going to find out, in litigation for social and economic impact, and it just hit me this would be a great topic for Friday Forum, so I asked if he would come in, and he graciously agreed to come in from DC. So I will read a quick bio here and then let Nick come up and begin his talk. Nick Sansone is an attorney at Public Citizen Litigation Group, which he joined in November 2022. Nick previously served as Public Citizen's Supreme Court Assistance Fellow during the 2016-2017 term. In that role, he worked on Supreme Court filings. Nick graduated magna cum laude from Harvard Law School in 2015, where he served as Vice President and Treasurer of the Harvard Law Review and volunteered regularly with the gay, lesbian advocates and defenders. He went on to clerk for the Honorable William J. Cayetta, William J. Cayetta Jr. on the U.S. Court of Appeals for the First Circuit, the Honorable David S. Tatel on the U.S. Court of Appeals for the District of Columbia Circuit, and the Honorable J. Paul Oatkin on the U.S. District Court for the Southern District of New York. Nick arrived in his legal career after pursuing stints as a college writing instructor, wildland firefighter, and performance gymnast. He continues to study dance and movement and is a published author of 2 novels and several short stories. In his free time, he enjoys hiking, distance running, karaoke, languages, and cooking meals for friends and loved ones. And I'm thrilled to welcome here today, Nick, come on up.
Hi all, thanks so much for having me, and thanks, thank you. Very grateful to be here, and thank you all for turning up. Really looking forward to speaking with you all today. I've got some sort of remarks planned just to sort of give you a sense of what we do at Public Citizen and what I do, and sort of how we use litigation as a tool to sort of fight for social and economic change. But I'm really looking forward to the question and answer portion. I want to make sure we leave plenty of time for that, so that we can sort of hear what's on your mind and have a bit of a conversation. So as Mark said, I'm an attorney at Public Citizen Litigation Group. They will be very, I'm sure they will want me to say that everything I say here is entirely my own, and I do not speak for them, although I obviously work there and we have shared values, so I don't think I'm saying anything that would be too objectionable to them. But we're, at Public Citizen, it's a nonprofit consumer, worker, and environmental advocacy organization. We're nonpartisan, but given our substantive interests in economic justice, regulatory safeguards, and the rule of law, means that we do sometimes butt heads with this administration around certain substantive issues. So it's a big organization. We have a lot of different sort of arms. We have a lot of policy people who advise policymakers, lawmakers, professionals in a variety of different substantive areas like environment, access to medicine, democratic governance, those sorts of things. But as Mark said, I work as a litigator. And what that means is we bring lawsuits that we sort of average person, workers, consumers, people impacted by climate change, by economic injustice, social injustice, and the like. So when I say impact litigation, that means, as a lawyer, you can bring a lawsuit. We tend to be very sort of intentional about the lawsuits that we bring, because we want to achieve a just result, not just for our client, but we know that, when courts, particularly when you go up into appellate courts and up to the Supreme Court, what they say in any given case is going to affect how judges and how courts handle future similar cases. So we want to make sure that we are encouraging the courts to announce rules of law that are, again, not just going to benefit our clients, but are going to benefit, other people who are sort of in the same boat moving forward. So one of the ways that, one of the reasons that we think this sort of impact litigation work is important is when you have powerful institutions like the federal government, like big corporations, they can afford to be very strategic because they're in court all the time. And they can say, oh, well, we'll let this case go. Maybe we'll settle the plaintiff out of court because if we move this forward toward a resolution, it might create a rule of law that we don't like. And so those sort of repeat players in the system, as I say, can be strategic. Whereas if you're somebody who, maybe you got cheated out of your wages, or, you were discriminated against, or, you had something happen to you personally, hopefully that's going to be the only time you're in court in your life. And so you're really just sort of focused on getting redress for the thing that happened to you, and you're not necessarily going to be focused on, what rule of law am I creating? How can I use my case to create impact down the road? So that's where we come in. We try to leverage, particular injuries, particular situations, to look at the broader social impact that they could have, and pursue cases that we think create a good opportunity to do that. So what I thought we would look at today is I think a lot of sort of how this operates in practice can be best sort of illustrated if we look at a few concrete cases. Because I think there's a sort of, I don't want to call it a myth, but there's this sort of understanding, we all know these sort of big court cases, like, the Obergefell, the right to gay marriage, Roe versus Wade, Gideon versus Wainwright, which established that everybody has a right to a lawyer in a criminal case. Every defendant has a right to a lawyer. And we think of these sort of big sweeping victories, and they're very important, and they happen sometimes, but they don't always play out that way. And so I thought we would take a look at some of the nitty-gritty, because there's often not a sort of clear victory or a clear loss. It's often much more a sort of negotiation. You try to get the advantages you can, and then you take the setbacks that you have to. And so as we go through, I've sort of picked out 4 cases that I've been working on that sort of walk us through the various stages. Hopefully we'll get to all of them, but as I said, I want to make sure we leave lots of time for questions. As we're sort of going through them, I want to sort of think about what does a win actually look like, and what does a loss actually look like? And as we sort of look at these wins and losses, as these litigations sort of progress from stage to stage, you can think about what are some of the strengths of litigation as a tool for advancing social causes, and what are some of the weaknesses? Where does it actually prove difficult to establish enduring change, particularly in the current environment with very politicized courts? And sort of at the end, maybe think a little bit about, well, why bother at all? Hopefully there are reasons most complicated of the cases we're going to look at. But one of the cases that we brought was on behalf of a nonprofit called the AIDS Vaccine Advocacy Coalition. We had a couple of other nonprofit organizations as well who joined the lawsuit, who are organizations that do international aid work for vulnerable communities throughout the world. And they receive funding, grant funding, from the US State Department and USAID. So what prompted this case, as many of you, if not all of you, probably remember, back on January 20th, 2025, when the new president was inaugurated, one of his first actions was to issue an executive order placing, at that time, what he said would be a 90-day freeze on all foreign aid. And this was enormously disruptive, not just because these organizations and the communities who work with the recipients of federal grants rely on this money. Just essentially, there was no warning, there was no wind-up, no process, and so overnight, communities that thought they had money for vaccines, thought they had money for food aid, thought they had money for the things that they need in order to fulfill their basic life functions, all of a sudden, overnight, the tap was shut off. So even though the president styled this as, it's a 90-day freeze, and we're going to evaluate the projects that we're funding, and then at the end of 90 days, maybe we'll bring some of this foreign aid back. These organizations and the communities in which they work, they don't have 90 days to just sort of have no access to funding. So we brought a lawsuit challenging the freeze at that time, and we sort of had two principal buckets of kind of legal theories. First, we said that the president's order shutting off foreign aid was unconstitutional. So, as you all know, the Constitution sort of divides our government into three parts. We have the legislative branch, which is Congress. They write the laws. We have the executive branch, which is headed by the president. The job of the executive branch is to, in the words of the Constitution, take care that the law be faithfully executed. And then we have the judiciary. And so our constitutional theory is that this foreign aid money, this foreign assistance funding, was required by Congress. I mean, Congress wrote laws appropriating money to go toward various humanitarian purposes across the world. And so if you're the president, your role under the Constitution is to carry out the law as Congress has told you to do it. You don't get to unilaterally decide, well, I don't like that Congress has told me to spend foreign assistance money, so I won't do it. That just flatly contravenes your role. That was sort of our constitutional theory. And then in the statutory bucket, Congress in 1945 enacted a law called the Administrative Procedure Act. And basically, to a sort of simplified version, called the APA, a sort of simplified version of what the APA provides is that when an executive agency, so like in this case the State Department, takes action that is arbitrary or capricious or contrary to law, injured parties can go into court and challenge that action. And so here, we had multiple theories. One is that the just sort of immediate shutdown of all foreign aid overnight with no warning, with no process, was absolutely arbitrary because it was so damaging in proportion to the president's stated goals, which were to evaluate these funds and make sure they were going to appropriate grantees. You can still do that. You can still conduct that evaluation while continuing to disperse the money. We also said that the shutdown was contrary to law. Because again, as I've said, Congress passed various appropriations laws, basically telling the president to put this money toward foreign aid. So he violated those laws requiring him to spend money. And there's another law called the Impoundment Control Act, which provides that the president can ask Congress to rescind money that he doesn't want to spend, but there's a process for doing that, and he had not followed that process. You have to secure congressional authorization before refusing to spend money that Congress has told you to spend. So those were our theories, and now we sort of get into the nitty-gritty, the sort of back and forth of how this actually plays out in court. And as I said, this case is definitely the messiest of the ones that we'll talk about. So apologies for getting a bit deep in the weeds, but I've tried to sort of break it down in sort of step-by-step way. So initially, we go into court on an emergency footing, right? Because as I've said, these communities and the organizations that are working in the communities can't operate, can't survive. In many cases, people can't actually live without the aid that they rely on. So we saw what's called a temporary restraining order, which is basically you go right into court and you say, this is an emergency, this is so illegal, it's causing so much harm, we need it to stop right away. We know that the court needs time to evaluate the merits and figure out who is actually right in the lawsuit. But while that is going on, we need you to put an end to the damaging thing right now. So we went into court and pretty immediately got a temporary restraining order. The courts agreed with us that this 90-day freeze of foreign aid was arbitrary and capricious. There are ways the government could have gone about an evaluation of its foreign aid spending that wasn't this disruptive, that didn't cut off access to resources that people needed. And the court also agreed with us that immediate action was necessary in order to prevent irreparable harm to the organizations we represented and again to the communities across the world, some of the most vulnerable communities on earth with whom they work. So the government appealed right away. They said, no, let us continue to starve the world. And the appeals court dismissed the government's appeal. Then the government went right up to the Supreme Court and they said, hey, Supreme Court, please, we need to be able to cut off all foreign aid right now. And the Supreme Court denied review as well. Four of the 9 justices dissented. They would have given the government what it wants, which is to be able to cut off foreign aid right away. But the other 5 ruled in our favor. So, victory, right? The court required $2 billion of foreign aid to go out the door to cover that period between January 20th and February 13th when the sort of freeze was in effect. Okay, so it would be great if the story ended there. It gets messier. So, as I said, the temporary restraining order was temporary relief to just sort of freeze the status quo while a case went on, to make sure that the money continued to go out the door. But the court still had to evaluate our legal claims and determine ultimately who is right in this lawsuit. So while the court was making that determination, the government said, well, good news, we've ended the freeze. We were supposed to do a 90-day freeze. You told us we can't do a 90-day freeze. So we're just canceling all the grants. It's not a freeze anymore, this is permanent. We're just going to cancel as many as many grants as we can. Good, right? We're in compliance with the court order. We're getting what we want. We're still starving the world. This is great. So between February 13th and March 11th, 9,900 out of around 13,000 USAID and State Department awards were just canceled with no explanation, no justification, just, we're not doing that anymore. Your grant is over. Stop your work. So of course we challenged that because that's still illegal for all the same reasons that the freeze was illegal. And if anything, it's worse. It's permanent. It's arbitrary. It's capricious. It goes against the appropriations laws that Congress has enacted, saying you have to spend this money. And it goes against the president's constitutional duty to follow Congress's laws, to execute them, and make sure that they're implemented properly. So on March 11th, the court sort of evaluated we moved for a preliminary injunction, which is still a sort of emergency posture. It's similar to a temporary restraining order, but it's like a little bit more longer lasting. A temporary restraining order is like, it can only last for like 2 weeks, but a preliminary injunction is a little bit more durable relief. And we got kind of a mixed result there. We got a qualified victory. The court repeated that the initial funding freeze, the 90-day freeze, was arbitrary and capricious, just like the judge had said. But this subsequent mass termination of the contracts, if you remember when I said the Administrative Procedure Act, the sort of statute that let us bring our claims, it goes to whether an agency action is arbitrary, capricious, or contrary to law. And the court said, well, initially, the action that you challenged was the 90-day freeze, and I ruled on that. And now you're challenging a mass termination. I get that that might be illegal for all the same reasons, but it's not the same action. So that's not what you challenged, so I have to reject your challenge to the mass termination. If you want to challenge that, come back, modify your complaint, which is the legal document that initiates a case. Modify your complaint, and then we can talk about the mass termination. But, so that was negative, obviously. But then the positive was the requirement of an agency action. That's part of our statutory claim, right? That's our claim under the laws of the United States. We still had our constitutional claim, which is like under the US Constitution, the job of the president is to execute the laws of Congress. You're not doing that. That violates the Constitution. And the court agreed with us on that. The sort of distinction is that if we're challenging the mass termination of contracts, then the remedy is grants. If we're challenging the mass termination of grants, then the remedy is you bring all those grants back. But nobody has a sort of constitutional right to a particular grant, right? We're saying that the government is the president is violating his constitutional duty by refusing to spend the money that Congress has spent. That violation could be remedied if the president just spends that money, gives it to different grantees. It doesn't have to be you. Maybe your grant got terminated and that's too bad, but as long as that money goes somewhere, the president is following the law. He is doing what Congress has told him to do, which is to make sure the money gets spent. So, hold that thought in your mind briefly about the constitutional claim. We're going to go back to the sort of agency action claim, our statutory theory. Because as I said, the court held, probably this mass termination was an arbitrary and capricious agency action. It's just not the action you initially challenged. You initially challenged a freeze. So of course we then go and we amend our complaint and we say, okay, well now we're challenging the mass termination. Now we want you to rule on this and invalidate all these grant terminations. In other words, bring back all the grants that you canceled. So the government responds, we're not going to say it wasn't arbitrary, we're not going to say it wasn't capricious, and we're not going to say it wasn't unlawful. What we're going to say is you sued in the wrong court. Because one of the tricks of the Administrative Procedure Act, which is the vehicle that we sued under, which is the vehicle for challenging arbitrary and capricious agency action, is that sort of claim is only available if you can't seek relief through some other mechanism. And what the government said is you're essentially bringing contract claims. And there's a special court called the Court of Federal Claims, and they evaluate contract claims. When you have a contract with the government and the government breaches its contract, that's the court you have to go to. And we responded, well, we're not challenging. We're not raising a contract claim. What we're saying is this policy of mass termination of essentially all foreign aid is arbitrary and capricious. We're not saying there's any particular term or condition in our grant or in our contract that you violated. In fact, everything that the government did was perfectly consistent with the terms of the grants themselves, because the government can terminate grants if it wants to. We were challenging the policy, so our claim doesn't belong in the Court of Federal Claims, this sort of special contract court. And another reason that it wouldn't make sense to bring these claims in the contract court is the contract court can't order the reinstatement of the contract. It can pay you out damages that you've suffered as a result of a breach of contract, but it can't order the government to restore the contract. Whereas under the Administrative Procedure Act, the law we were bringing the suit under, the remedy is to undo the unlawful government action. In other words, to undo the cancellation of the grant. The court agreed with us, but then while all that was going on, the Supreme Court issued an opinion in a case called California versus Department of Education that challenged a similar mass termination of grants. And they said by a 5-4 margin, I believe, yeah, 5-4 margin, yes, these sorts of challenges to mass grant terminations probably belong in the contract court. They didn't rule definitively, but they said, that's what we think. Lower courts go out and do with that what you will. So right now, we're still sort of waiting for more definitive guidance, but things are kind of stuck on that claim. In other words, the claim of, can we get our grants back? It's an open question. We need to wait for more guidance from the Supreme Court before we can move forward on that. So, not quite a stirring victory. We're just sort of stuck there. But things get even a little bit more complicated still. So, if you remember, the statutory claim was to try to get the grants back. We were challenging a mass termination as arbitrary, capricious agency action. We still, however, have our constitutional claim, right? Which is, if Congress says go spend foreign aid, you, the president, can't just refuse to do that. You have to do what Congress tells you to do. So therefore, again, it's a remedy that's less helpful to our particular clients, because the remedy for that constitutional violation is just that the president then has to spend the money. It doesn't have to be on our clients. He doesn't have to reinstate the grants, but he has to spend it on someone. So that aspect of the ruling, the government appealed. And it said, it went to the Court of Appeals and it said, you know, the constitutional ruling was wrong. It's fine for the president not to spend the money that Congress has told him to spend. While the appeal was sort of processing, remember the district court, the trial court, held that there was a constitutional violation, held that the president has to start putting money out there. The government did not. They filed sort of periodic status updates with the trial court saying, oh, we're still figuring it out, we're still figuring it out. And meanwhile, not spending any money. So that goes on through all of April, throughout the entire summer, until August 13th, when the government wins its appeal, and the Court of Appeals vacates the injunction that the district court issued. In other words, the trial court had said, you must spend. The Court of Appeals said, no, you don't have to. Interestingly, the Court of Appeals never said that what the government was doing is constitutional. What they said is, is that the president is violating a statute, is violating an act of Congress. That is not a constitutional claim. That's a claim that he's doing something that's inconsistent with Congress's laws. So you have to file a claim saying, a statutory claim. That's not a constitutional violation. And of course, we had also brought a claim saying that the president was violating this, I mentioned earlier, this Impoundment Control Act, which basically says if the president wants to withhold money, he has to ask Congress. So we had made that claim, but the court said, well, you also can't bring a claim under that statute, because that statute can only be enforced by Congress. So you're kind of out of luck here. We obviously completely disagreed with that entire analysis, so we immediately asked the Court of Appeals for an emergency rehearing. And when you ask the Court of Appeals, there are multiple judges who sit on the Court of Appeals. The first time they hear a case, it's usually on a 3-judge panel. When you ask for a sort of rehearing, it's all the judges who consider that. And so we asked all the judges to rehear this case, and while they were deciding whether to rehear it or not, they put the Court of Appeals decision on hold. They stayed it. So the effect of that was that the original injunction, the original requirement to go forth and spend the money, went back into effect. The government then went back to the trial court and they said, look, there's all this stuff going on in the Court of Appeals. Don't you want to stop the injunction that you issued? The injunction that requires us to go forth and spend the money? And the trial court said, no, I don't think so. I think I was right the first time. So, unless and until the Court of Appeals, says my injunction goes away, my injunction stays in place. So then, the government leapfrogged to SCOTUS, and they said, hey, Supreme Court, why don't you get rid of the district court's injunction? And while the Supreme Court was sort of considering that request, the appeals court, which if you'll remember was sort of deciding whether to hear the full case, deciding whether to rehear the case, said we're not going to rehear the case, but we do want to clarify that there is actually a path forward for you. So we're still going to get rid of the trial court's injunction, but we're going to make clear that our opinion doesn't foreclose you from saying the president violated the underlying appropriation statutes, that the ones that said, here's $200 million that has to go toward XYZ purpose. Here's $400 million that has to go toward XYZ purpose. You can bring a statutory claim under those statutes. So go do that. And so given that the injunction was now vacated, the government said, okay, SCOTUS, now we don't need you to do that. So we lost, but as I say, a window remained open. And now we get to the final most depressing part of this saga. So, having this guidance from the Court of Appeals that we can still push forward on our claim that the president's actions were inconsistent with the underlying appropriation statutes, we advanced exactly that claim in the trial court, and we said, enter your original injunction, but just based on this different theory, and do it fast, because a lot of these funds were coming into late August at this time. A lot of these funds expired in late September. So we said, do it quickly. And the district court, who has been our friend all along, who has completely understood all of these theories, grants us relief, enters another injunction on September 3rd. Requiring, yet again, the government to spend these funds that are now going to expire in a matter of weeks. So, the sort of depressing little coda on this, I mentioned that there is a process under the Impoundment Control Act. There is a process for the president to ask Congress to rescind the funds that it has appropriated. What the president So the president, on August 29th, while all this is going on in the district court, sends a request to Congress and says, hey, claw back the funds. Congress is not going to do that. Congress, there's a 0% chance that Congress is going to pass a law rescinding these funds that it has told the president to spend. But if you'll recall, those funds are going to expire on September 30th. So the president makes the argument, well, while Congress is weighing this proposal, we shouldn't be obliged to spend the money. And of course, the only reason we're so close to the deadline now is that the president has not been spending the money. So the trial court immediately rejects that argument and says, like, you sort of dug your own grave here, bub. Spend the money. I don't care that there's this pending request that Congress rescind the funds. Congress hasn't rescinded the funds, so you're stuck. Goes up to the appeals court. The appeals court does not give the president the time of day. Then, September 26th, 4 days from the expiration of the funds, the Supreme Court grants the government's request and says, you're not obliged to spend the funds because there's this pending request to Congress. And then 4 days later, those funds evaporate. So that's $4 billion of foreign aid that is now gone. That took longer than I expected, and it's also a super depressing note to end on. But I do want to make sure that we have time for questions. So maybe I'll see if anybody has questions right at the moment, and if not, I can delve into a slightly less complex set of cases.
Yes, please just raise your hand if you have a question and I'll run the mic over to you.
What does it mean when you said that the $4 billion funds just expired? Like, where does that money go if it was already allocated?
Yeah, it stays in the Treasury. So whenever Congress sort of writes an appropriation and it says, we authorize the expenditure of, let's say, $3 million to be spent by, September 30th. If that $3 million is not spent by September 30th, it just stays in the Treasury.
Two questions that are wording questions. A grant is not a contract. And you refer repeatedly to Congress passing a law. And my recall from Sesame Street is the president has to sign it before it's a law. Is there a reason you keep referring to Congress passed a law rather than Congress passed, the president signed, and that made it a law?
No, that's shorthand.
And grants not contracts? Why is that different?
So that's a little bit technical, but yeah, I did slip up and refer to them as contracts a few times. The difference is a contract is sort of a bilateral exchange of promises. It's like, I will paint your house if you give me, $100. And so there's obligation on both sides. Whereas a grant is the government sort of gives money to an organization. It gives it for a designated purpose, but the organization that receives the grants doesn't sort of have to make a promise in exchange to the government. Yeah.
Hi, thank you for your presentation. I was wondering, is there any push by your organization to get any congressional law to state that not only does the government have to spend a certain allocation by a certain time frame, but also the purpose intended has to remain intact, and that the review process has to go on while, has to occur while the funds are still being dispensed?
Yeah, that's a great question, and I think it sort of highlights an important question that, if I had sort of gotten to the more optimistic part of my remarks, I think is very astute and important, is that even when we sort of see these, these setbacks or these failures in litigation, this is one strategy for advancing, for holding the government to account. This is one way of trying to do it. As you point out, there is also legislative options. So, often the setbacks that we experience in litigation, as you point out, can inform what we want Congress to do to sort of close these gaps or prevent this sort of bad behavior. So, I myself am sort of use this tool, the litigation tool, but our organization is definitely very active in lobbying Congress and sort of identifying these holes in our laws that need to be filled in order to prevent, this sort of bad behavior on the part of the president.
Yeah, I kind of get the impression that the litigation you instituted was kind of cutting a new path. Is that a fair statement? And if so, might that be helpful in the future, I guess?
Absolutely. We have found ourselves cutting a lot of new paths in the last year or so because we've been seeing a lot of unprecedented action on the part of the administration. I'm not trying to suggest that presidents past have not also been, done bad things, but I think a lot of the ways that this government has proceeded by sort of dispensing with a lot of the sort of procedural requirements and things like that even very bad prior administrations have sort of felt themselves to be bound by, has meant that we have had to litigate a lot of novel areas of law, and to do so in very fast procedures, because, I think as this litigation provides a decent example, one strategy that this administration has is to do something really quick and cause as much sort of sunk in harm as it can before a response is possible. And so, I think we've been really sort of testing out a lot of the sort of limits of what can the executive branch lawfully get away with and what responses are available. And I think some of that has come from litigators to really try to come up with novel solutions to try to respond to these provocations. And I think a lot of it has come from judges too. I think this example has painted a pretty dire picture of the Supreme Court, and I have my thoughts on the Supreme Court, which I won't share, but there are a lot of judges out there, and some of them are really taking up the mantle of this moment and understanding that, okay, things aren't actually progressing the way that they usually do, and these sort of new situations or these new tactics require different responses. Absolutely.
Okay. Hi. Thanks so much for your presentation. I wanted to ask, in terms of social impact litigation, I'm sensing that there is a strong sense of coalition building, both on grassroots side of when you're talking about government relations, but also in terms of litigation. So I wonder with the cases that your organization takes on, how often do you, establish co-counsel in a way with different organizations, and what strengths necessarily do you all bring that maybe not other organizations may have? Since I think it's also a strength in numbers game, because how I'm sensing with your presentation is that the law is essentially treated, or the interpretation of the law oftentimes reaches to the limits of stop doing the bad thing, and then maybe government relations in terms of lobbying or advocacy work could reach more towards, so we've had this case telling us not to do the bad thing, what can we do moving forward? And so I think with different prongs in mind in terms of advocacy, how does your organization and you as a litigator work with different disciplinaries of that form of advocacy work, especially also if it comes to working with different firms or private or public, I'm not quite sure how that works, when you're pursuing a case like this?
Yeah, no, you're definitely hit the nail on the head. It really is a coalition strategy because, particularly, when we go against the federal government, but also when we go against well-resourced corporate defendants, they have a lot of resources to draw on, and as you say, it's a sort of strength in numbers at times. So we're very conscious of what our peer organizations are doing and what they're focused on, and if we have a case that we think touches on an area that they would be interested in, we're always in communication and sort of talking through our overall strategy. Which is not to say we always agree. I mean, certainly there are times when, our priorities are going to be over here and different organizations' priorities are going to be over here. And, I think navigating that is always a little bit of a balance because you want to make sure you're not stepping on anyone's toes. I mean, unless they deserve to be stepped on. I mean, if they're like, my priority is like starving hungry children, then like, yes, we'll happily step on your toes. But, assuming that we're all sort of have the same aims, I would say that we tend to try to keep our cases small rather than bringing in a lot of co-counsel, just because it can sometimes be helpful to like really keep the message focused when you're in conversation with a particular judge or on a particular issue with a particular set of clients. But I would say more broadly, we're definitely sort of focused on making sure that our approaches are harmonized. And some of that is just basic division of labor. Like, you open up the newspaper, you see, 20 bad things happening. You have the resources to maybe challenge 2 or 3 of them. So, you get on the phone with other organizations who were like, okay, well, do you want to get this one? We can handle this one, and just sort of make sure that everybody's sort of using it wouldn't make sense to have like 3 lawsuits all challenging the same thing when this other thing is going on over here and nobody's looking at it.
This is about grants and contracts. The grants go to the NGOs. The contracts they have are ongoing on the ground point of service, like where the AIDS drugs are being circulated, distributed. So those contracts were the ones that were broken in good faith. So I don't know, I wanted to mention that. There's a lot of incompetence in some of the filings. Perhaps you don't see them, but in a number of them, some judges, I think, just laughed the offerings from the administration out court. I don't know if you see any of that. I don't know if you have a comment on that. The 3 other case studies, maybe you could just give a mention of them.
Yeah,
I appreciate your effort. Thank you.
Yeah, absolutely. Well, I think since you mentioned a little bit of comic relief from the administration, I'll jump to the sort of one that's the most recent. So, as you all probably know, the 250th anniversary of our country is coming up July 4th. The president, since October, has repeatedly said, I want to build a big old arch, in commemoration of this grand event. And since October, he's been saying it, and he's got his little model there, and he posted that little thing on Truth Social. We're gonna build an arch in DC. It's gonna be great. It's gonna be the biggest arch, bigger than the Arc de Triomphe. It's gonna be amazing. So that all sounds nice, right? Why not have an arch? The problem is where do you want? Well, a few problems. But one big problem is he wants to build it sort of right between Arlington Cemetery and the Lincoln Memorial, which is a space that has for a long time been very intentionally kept vacant because the sort of reciprocal views between the Lincoln Memorial and the Arlington National Cemetery is designed, again, very intentionally by the architects who sort of put the capital together, to serve as a visual reminder of the sort of the bloodiness of the Civil War, the ideals for which they were fought, and the sort of enormous rupture that our country faced in the 19th century as a result of white supremacy and racism and just the inhumanity of slavery. So to just sort of plunk a big arch right there in the middle of that is not ideal. And you know, a lot of veterans and other people who utilize that space are like horrified by this idea. But not only is it like aesthetically a very questionable choice, it's also illegal because Congress has passed laws precisely because we want the design of the monumental core of Washington, D.C. to be very intentional and to tell a national story that, you know, has some democratic buy-in and isn't just sort of one person's aesthetic preferences, you know, plunked down for everyone. So there are laws that basically provide you know, a process. If you want to build a monument, if you want to build something commemorative, it has to go through Congress. Congress has to authorize it, and then there are a number of other steps. It has to go through environmental review, it has to go through, you know, the place he wants to build the arch is very, very close to Washington National Airport, where we had a very bad plane crash about a year ago. So, like, it poses aviation hazards. There are a lot of reasons for process. So we say this is illegal because it is. Congress has said you can't build unless we say you can build. And again, they sort of came back with arguments, some, you know, kind of weak arguments about why maybe it's legal. But their primary argument is, well, who knows about the arch? You know, you have to, if you're asking for the court to do something, you have to come in here and show that there's going to be an arch. And the National Park Service said, oh, we're not going to grant a construction permit until all the laws have been followed. And we're like, well, but the president has said there's going to be an arch. He's said it's going to be there for July 4th. He's said this multiple times. He's said this for months. And there's important, like, context here, which is they tore down a third of the White House in October on the president's direction. The White House is on National Park Service land. He didn't seek a construction permit from the National Park Service. He just did it. So we went to the court and we said, well, our evidence that there is going to be an arch is that he has told the American people that this is what he's going to do, and when in the past he has said this is what he's going to do, he has done it. So anyway, yesterday we had a hearing before the judge in this case, and she asked the government point blank, what is the plan for this arch? Will you just, how far along is it in the planning process? And the government counsel said, well, I don't know, and it's not my job to deny that there's going to be an arch. It's the plaintiff's job, our clients who are veterans who intend to be buried in Arlington National Cemetery, it's their job to prove that there's going to be an arch. And so we pointed to this language, right? President Trump has said, this is a direct quote, we're building an arch like the Arc de Triomphe, and we're building it by the Arlington Bridge, the Arlington Cemetery, opposite the Lincoln Memorial. That's a direct quote. The White House spokesperson, again, has a direct quote saying the arch will be one of the most iconic landmarks, not only in Washington, D.C., but throughout the world. And President Trump's bold vision will be imprinted upon the fabric of America and be felt by generations to come. And to this day, even now, at the time of the hearing, whitehouse.gov says that President Trump has announced plans for a new Independence Arch in Washington, D.C. to coincide with the 250th anniversary. So the judge was not pleased, I think, with the government's sort of squirrely response to try to say, well, who knows about this arch? She said, look, they've come forward with evidence that you're going to do what you said you're going to do. What's your response? Like, what do you have any, can you deny it? And the government just sort of kept coming back to the burden and saying, well, it's their job to show that there will be one, not our job to deny it, even though we're the ones with all the relevant information. So the judge was not pleased, as I said, and so today by 4 p.m. We have to talk to the government's counsel and see if they're going to agree not to build this thing without giving advance notice. We suspect they're not going to agree to that, and we'll go from there. To be continued.
All right, we still have time for one more question
this is all one big stress test of the system, and the point of the administration doing all these things is that maybe no one in the past even thought to do it. And like, I'm just thinking, when I took like high school social studies, they told us that Congress had to approve of war plans. And then obviously now, like, it just doesn't seem like Congress does much of anything, and the president and the executive branch can kind of do what they want, whether it be cutting funding or cutting grants or starting wars or anything like that. So is that like a fair assessment? It's just stress testing.
Yeah, I think it is a fair assessment. I think they're working to get away with as much as they can get away with. And I think maybe this actually is a good note to end on, because I did intend to end on a little bit of a note of optimism rather than just everything's horrible. But like, okay, so why bother? I mean, we've had some victories and we've had a lot of defeats. And, you know, okay, so like interstitial victories are better than total losses. So I mean, that $4 billion of foreign aid money evaporated, but we also got $2 billion out the door, and that's $2 billion that otherwise would not have been there. This litigation can slow things down, and so if you're an injured party, so say for example you're a nonprofit who's performing services, you know, in the global community, and your grant money is all of a sudden gone. If you get, you know, you obviously want that grant money back indefinitely, but if you can at least get a month, that's time to like plan for the next step. You know, it's not ideal, but it's better than like we're cut off overnight. You know, and I think this example of the sort of government attorney getting up there and saying in open court, well, don't actually take the president seriously. You know, it's important to create a record of those things and make the government own up to what it's doing, make it come forward and like make its arguments. And you know, unfortunately, some of them are getting purchased with courts, but not all of them are. And the more they have to look ridiculous, the more people see that. And you know, maybe the more galvanized people are to create some sort of structural change. You know, I skip some of these, but like also just, yeah, I think what I'll end on is just this idea of galvanizing people. I mean, if some of you are outraged by what you're hearing in the conduct of our administration, like, you know, we're all sort of doing what we can, and it's easy to get stuck in a silo and be like, oh my gosh, like I'm like litigating these cases and we're just like losing, or, you know, kind of winning but also kind of losing, and it's hard and it's exhausting. But like, we're not the only ones out there doing that work. You guys aren't the only ones out there doing that work. Like we're all sort of contributing in our different ways, and it's important to remember that like this all fits into a bigger picture. And so to your point about like, is this, you know, an existential, you know, is this like a real sort of crisis moment? I mean, you know, in some ways it does seem like a real stress test for the system, and so we have to figure out, like, in light of that, what are the various ways we're going to respond, and how are we going to support each other while we respond? And sometimes even the losses can be real, you know, can bring out a lot of fire. You know, I am a terrible like organizer. Like I would be horrible at like giving a speech to be like, yeah, let's like all, you know, fight. But like some people are brilliant at that, and so maybe something that happens in one of my cases pisses someone off to the extent that they go out and like do something that has a totally different impact. So yes, things are bad, but I also continue to remain optimistic that we'll find ways to fight back, and I don't know, that's our job, is to, and also to try to keep ourselves breathing and calm to the extent we can as we do that and support each other.
And with that note, let's give a hand to beautiful day. Next week, our speaker will be Sarah Livesay from Grand Prairie Friends, so we hope you come back. But yeah, I'm sure Nick is going to be up here, so